Commissioners are aware.
Thank you very much. All right, the commission is back in public session. No decisions were made during the executive session. We will now, however, be publicly reviewing those very matters. Item number 1 on this agenda, file number 2024-079 is tabled. File number 2024-123 is the next item. Attorney Jaslowicki.
Good morning, Mr. Chairman. Zach Jaslowicki for the Commission. This is file number 2024-123, seeking a no further action. This complaint alleges that members of the Coventry Republican Town Committee violated campaign finance laws based on their efforts to raise funds for flood victims in North Carolina following Hurricane Helene in October 2024. Complaint alleges that the organization with whom the CRTC was working was not a validly designated 501c3. Investigation revealed, however, that the organization Battles was in fact a valid 501c3 organized in North Carolina. As to the activities involved, investigation found that the CRTC promoted the relief effort on its Facebook page. These posts included the following: a list of supplies that were needed for the victims of the flooding, a list of physical locations where residents could drop off the items and supplies or make monetary donations, and they included a QR code to the 501c3, the 501c3's PayPal account, so residents could directly donate to them. CRTC spent approximately $198 making signs that promoted the relief effort, and the CRTC members, working alongside other volunteers, collected a large amount of tangible donations: backpacks, water, stuffed animals, and roughly $1,800 in monetary donations across these various drop-off locations. The money collected, along with a $300 personal donation by the CRTC chair, was used to transport the donations down to North Carolina. There's no evidence that any monetary donations or contributions were deposited into any financial accounts associated with the CRTC. So pursuant to General Statutes 9-607G, a lawful purpose of a party committee includes the promoting of the party. And pursuant to General Statutes 9-617, a party committee may make contributions to charitable organizations that are validly designated as having 501c3 status. Read in conjunction, the Commission can find that a town committee, in an effort to promote its party, may raise and solicit donations for a valid 501c3 organization. Evidence shows that the donations collected at various drop-off points by volunteers of the CRTC and other non-CRTC members went to the 501c3 either through the QR code or via the transportation of the collected donations. The donations did not go to the CRTC and were clearly intended for the charitable entity. As such, these donations were not subject to source and contribution limits, nor to the reporting and filing requirements of General Statutes 9-608. Any expenditures or contributions by the committee would, however, need to comply with those filing and reporting requirements. CRTC spent $198 approximately for signs to promote the relief effort. It was discovered in an investigation that the CRTC paid $125.13 for the signs, and that the chair of the committee paid the balance in the amount of $73. In its SEEC Form 20 filings, October 2024, the expenditure of the $125 was reported. However, the in-kind contribution of the $73 was not. However, working with SEEC staff, the committee treasurer amended this filing to properly include both the committee expenditure and the in-kind contribution. Also, the limited expenditure by the CRTC promoting the relief drive for the 501c3 via its Facebook page falls within the de minimis activity exception for reporting and filing obligations, and that is pursuant to General Statutes 9-601A, parenthesis B, parenthesis 18. Therefore, we'd ask the Commission to entertain a motion to adopt this findings and conclusion and take no further action on this matter.
Are there any questions or comments for council? None appearing with respect to file number 2024-123. It is the recommendation of council that no further action be taken. Is there a motion to that effect?
So moved, Commissioner Jello.
Second, Pietzu.
Moved and seconded. Any discussion? None appearing. Those in favor of the motion will raise their hands and or say aye.
Aye.
Any opposed? Any abstentions? None appearing. The motion carries with 4 voting in favor, none opposed, no abstentions. Next item on the agenda, number 3, is file number 2023-014. Attorney Ross.
Thank you, Mr. Commissioner.
For the
Attorney
record,
Ross, for the record.
I'm going to,
Yes.
Commissioner Pietz, I'm going to step out of this one. Thank you.
Yes, thank you. Yes, let the record reflect that Commissioner Pietzu has recused himself with respect to this matter.
I would also note the Commissioner Pietzu did also recuse himself in the executive session as well.
Right.
In a matter of a complaint by Aaron Crowless out of Southerton, Connecticut, SEEC file 2023-014. Before the commission, there is a stipulated agreement. This resolves the matter against the last remaining respondent, Michael Riccio, who's being represented by counsel today. The agreement calls for this matter to be dismissed, but it places Mr. Riccio on notice of the applicable statutes. I would ask that the commission adopt the stipulated agreement. I have spoken with Attorney Marino. He said his client is willing to sign it. I would ask that the stipulated settlement agreement be adopted pending the receipt of the signed and dated copy within 10 days. Thank you.
All right. Thank you. Any questions or comments for counsel? None appearing. With respect to file number 2023-014, it is the recommendation of counsel that the settlement agreement in this matter be adopted by the commission. And is there a motion to that effect?
So moved, Commissioner Jello.
Shannon, you're muted.
Second, Berquist.
Okay, thank you. And I should note for the record that there's a 10-day requirement that the agreement be signed and returned to the commission. With that said, those in favor of the motion to resolve the matter by way of the stipulated agreement will raise their hands and or say aye.
Aye.
Any opposed? Any abstentions? None appearing. The motion carries with 3 voting in favor, none opposed, and I guess and 1 abstention. Right, item 4 on the agenda, file number 2024-043.
Thank you, Mr. Commissioner. Attorney Ross, for the record. In a matter of a complaint by Kenneth Greenberg, this out of Greenwich, SEEC file 2024-043 before the commission day is the findings and conclusion. The complaint alleges that the Re-elect Fred 2023 committee, as well as the Re-elect Lauren Rabin Select Woman and the Re-elect Bunkins 23 committee failed to properly report expenditures, shared expenses, contributions, events, and donations on various financial disclosure statements. There were several allegations made against respondents in this matter. Joseph C. Marino, who was the treasurer for both the Re-elect Fred 23 committee as well as the Re-elect Bunkins 23 committee. Nicole Platt, who was the treasurer for the Re-elect Lauren Rabin Select Woman committee. Fred Carmelo, Lauren Rabin, and Jacqueline Bunkins, Bunkins are all respondents in this matter. After an investigation, the commission can determine that in regards to the allegations about missing information in violation of Connecticut General Statutes 6-608, respondent Romero did a great job in correcting the filings for the committees at issue here. As it relates to the allegations that essentially the rent was not shared on a pro rata basis in violation of 9-616(5). It appears that the committees involved here did decide to appropriate or apportion rent based on the fact of how much space and signage was used by each campaign. That is, by the commission standard, not clearly erroneous and therefore permissible. There's another allegation in the complaint that essentially the campaigns received a impermissible business entity or organization contribution. The test that the commission used to determine whether or not you have an impermissible business entity or organizational contribution is called the use of facility test that was articulated in the advisory opinion. 2010-02. Basically, under the test here, the ownership interest of both 1162 East Putman Avenue and 261 East Putman Avenue, which were both locations used as campaign headquarters by the various committees. In this particular case, it appears that the ownership interest will make that discount available and on similar terms to other committees, and so therefore you don't have a impermissible business entity or organization contribution. And in one of the other allegations in this complaint was essentially a violation of 9-140, which involves a failure of the of respondent Romano to provide a explanation of the eligibility requirements for absentee voting, as well as a written warning that if you do not meet the eligibility requirements, an elector who files a absentee ballot application could subject themselves to civil and criminal penalties. The allegation was that that information was not contained on the letter that accompanied several absentee ballot applications. Respondent Romano was able to provide the commission with a copy of a letter that did contain the appropriate warnings as well as the appropriate requirements for absentee voting as the law existed at the time. Based on this, I think that the complaint can be dismissed while also putting all respondents on notice of the applicable rules. I think that's a fair and accurate disposition. And I would just note to the commission, again, I want to correct a Scrivener errors in paragraph 17, not paragraph 25. I think an and needs to be placed in between the name of the two committees. But with that, I would ask the commission to adopt the findings in conclusion.
All right, any questions or comments for council on this matter? None appearing. With respect to item number 4, file number 2024-043, it is the recommendation of council that the commission take no further action with respect to the complaint in the matter. Is that moved?
So moved, Commissioner Jello.
Second, Pietzi.
Moved and seconded. Any discussion? None appearing. Those in favor of the motion will raise their hands and or say aye.
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 Motion carries with 4 voting in favor, none opposed, no abstentions. Items 5 on the agenda are tabled. And at this point, Chair will entertain a motion to go into executive session regards to a preliminary draft and agency consideration of a draft memorandum of understanding for discussion of IT services. Is it moved?
So moved, Commissioner Jello.
Second, Pietzi.
Moved and seconded. Those in favor of the motion to go into executive session will raise their hands and or say aye.
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 Opposed? Motion carries. Thank you very much. All right, the commission has concluded its executive session. No decisions were made. Before we adjourn, I'm sure I speak for everyone in expressing our condolences to Mike Agello for the loss of his cousin, former Attorney General of the state. And with that said, the chair will entertain a motion to adjourn.
So moved, Commissioner Jello.
Second, Pietzi.
Moved and seconded. Those in favor of adjournment will raise their hands and or say aye.
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 We stand adjourned. Thanks, everyone.
Thank you. Thank you, Steve. Thank you, guys.
Yep.